Good morning, everyone. Happy rainy Monday morning. My name is Heather Edwards. I'm an attorney with the law firm of Girard and Edwards. Our firm has the privilege and pleasure of representing the school district in the area of special education. So I get to work with Carol and her fabulous team when we deal with special education due process issues, complaints, that sort of thing. Just a little bit about our firm. We represent school districts, county offices of education, SELPAs, charter schools. I personally have probably dealt with close to 1,000 due process complaints over the last 11 years. So we've seen it all. We've seen when things go sideways with families, and we do a lot of trainings like this to try to keep school districts and county offices out of trouble to the extent possible. So Carol asked us to come in and share with you some of our lessons learned because we know that you're really out in the trenches and you're dealing with these things on a daily basis. And you know, the law, our senior partner always says, the law really is common sense and a whole bunch of procedures. And so hopefully you've all got the common sense part taken care of. And so today we're going to talk a lot about some of the procedural aspects of special education laws that are really, really critical when we deal with rights of students and their families with disabilities. So the purpose of today's training, I'm going to move over here a little bit so I can see better. The California Department of Education, their special education division, they are charged with monitoring compliance at the local level in terms of special education procedures. So as a result of this review process that the school district has just gone through, we are required to notify and provide in-service training to staff of all policies and procedures. So that's why it really is important to make sure you sign in today. We have note cards that Carol has passed out. So if you have questions, we have a lot of material that by law we have to get through in 90 minutes today. So I'm going to be throwing stuff at you rapid fire. So if you have questions, normally I really like interactive presentations, but this is probably a little bit too large of a group. And a lot of times in these presentations, you start thinking of a particular kid that you're dealing with or a particular family. And so you want to get all your questions answered. If you can write down if you have questions, and we'll try to save some time at the end that we'll try to get to those. So if you have questions, Carol will walk around and grab those note cards from you. So again, this is technically a compliance training, and unfortunately, or fortunately, the key driver is an external motivator, which is the law, which is what we are mandated to do by law. But we also want to make sure you understand why you're being asked to do certain things for students with disabilities. So a lot of the questions that you might have that we're hoping we answer today are, why do we do what we do? What are we supposed to do? When do we do it? How do we do it? Who does it? And then how do we prove that we've done it? So much of what we do in special education is making sure that we've documented things appropriately so that we can either show to the parents or to a judge or to the Department of Education, yes, we've done this, and here's how we can establish that we've actually done it. So again, please be sure to write down any questions that you have, and we will do our best to try to answer those. So why is compliance important? A lot of times when we get a due process complaint, I'll have a school district director of special education call me up and say, well, we got this due process complaint, you know, we have this really challenging parent that we're working with, and they just, you know, got us on a bunch of little ticky-tack procedural issues. Well, procedures are half of the equation. So really, under the Supreme Court decision in the Rowley case, what it said was for students with disabilities to get an appropriate education, you have to comply with the procedures, and you have to make sure you've developed an IEP that is reasonably calculated to ensure that that student can receive some educational benefit. But if you get the procedures right, you're halfway there. So the procedures really do matter, and it's not just a little kind of, you know, technicality kind of thing. So we have process, following all the steps in the correct order within the timelines, and then we have the content piece of the IEP, making sure that it's appropriate and that we actually implement the IEP as we're required to. So we have an obligation to provide FAPE, a free appropriate public education, to all students between the ages of 3 and 22, unless the student has been determined not eligible for special education any longer through going through an appropriate assessment process and the team determining that they really don't meet the definition of a special education student any longer, or if the child has received a regular high school diploma. So those are really the only way that a student who has an IEP will no longer receive special education services. Diploma, they've aged out, or you've done an assessment and you've determined that they're no longer eligible for special education. So child find. So we're gonna kind of go through all of this stuff kind of methodically, kind of in the chronological order that you would deal with students with disabilities. So child find under the IDEA, which is the federal law that governs special education, talks about how schools have an affirmative obligation to find students with disabilities. It's really not enough for us to sit back and wait for parents to ask, hey, my kid just got a diagnosis of ADHD and I'd really like to have them assessed for special education. If we're seeing things in the classroom or on the playground or a variety of different environments, if we're seeing things that trigger our obligation to refer that child for special education, and if we don't, we can find ourselves in trouble in terms of litigation. So our obligation is to find students who have disabilities and need special education, or are suspected of having disabilities and need special education. So again, the parent's not required to ask for it, so we have to go out and find it. We can't take kind of a passive approach and wait for others to refer a student. So really, it's everybody's obligation in this room that if you feel like a child is struggling and may need special education, that we make those referrals. This also includes, we have an obligation to seek out and find even students in private religious schools that reside within our jurisdiction. We have to go out and find them. And so the school district has in place policies and procedures for going out and finding those students and offering them an IEP if they are eligible for special education services. Same with migrant and homeless youth. Even if students are advancing from grade to grade, that doesn't necessarily mean that they might not need special education. So there's a lot of factors that go into whether or not we are suspecting a disability. It also includes wards of the state. So the importance of general education teachers and the general ed teacher's role in this, because a lot of times a special education student or somebody who might need special education doesn't even become on the radar of special education staff or the special ed department until they've already been referred for special education. So the general ed side of the house becomes so important in this child find aspect to, again, seek out and find these kids who may need some additional assistance. So sometimes after learning from a parent about a student's diagnosis, some teachers take it upon themselves to provide informal accommodations without referring the student for an evaluation, which is very appropriate. I know our gen ed teachers do those kinds of things all the time to help struggling learners. So while schools can use those regular ed interventions to assist students with difficulties, IDEA requires staff to refer a student for an evaluation if the student, because of a disability, needs or is believed to need special education and related services. So a lot of times if teachers are making lots of accommodations and the number and the amount and the kind of those accommodations are increasing in frequency, that might be a trigger for us to say, yeah, this kid probably needs to be referred for special education, rather than us just to continue to make in-class accommodations. So if teachers suspect a disability, they should refer the student. A lot of times one of the problem areas that we see is where maybe you might be having a conversation with a parent and the parent says, gosh, yeah, you know, I just found out my child had an autism diagnosis. Maybe the parent has some concerns and the teacher would say, you should probably take your child to the doctor and see if you can get this worked out, and not making the referral for special education. So that's where we get ourselves again into some trouble, because we want to make sure, okay, now that red flag has been triggered, so we want to make sure that we are referring the student for a special education evaluation and not just saying, go check with your doctor, see if there might be something going on here. Also make sure not to dismiss the possibility of hidden disabilities. So we can't necessarily see all disabilities, right? It could be a mental health issue that's going on with a student, some sort of behavioral issue. So we want to make sure that we don't dismiss those potentials of hidden disabilities. Okay, so then once we make the referral for special education, then we have an obligation to develop an assessment plan for a student. So this is essentially a proposal to the parent saying, this is what we're proposing to do to evaluate your child in all areas of suspected disability. And so we have a form, if you're familiar with SACE, the Special Education Information System, the electronic kind of IEP paperwork. So you have an assessment plan in there that someone will fill out. And if an assessment is to be conducted, the district must provide a parent an assessment plan within 15 calendar days of the referral for an assessment. So that referral could come from a teacher, it could come from the parent. So no matter where the source of the referral comes from, we have to make sure that within 15 days we're getting that assessment plan to the parents to propose an assessment. The assessment plan has to be in the parent's native language. So a lot of times we need to account for the fact that, hey, we're going to need to kind of ramp up the timeline on this because we need to have time to get it translated into another language if the parent has another language that they understand. So that makes that timeline all the more critical to make sure we're getting the right people there to translate the assessment plan. Language must be easily understood by the public. So a lot of times these forms can be kind of complicated. So we want to make sure that the parent really understands what it is that's being proposed. The assessment plan has to include the types of assessment to be conducted, and that doesn't necessarily mean every single test, you know, the Woodcock-Johnson and the Wyatt and the Basque, and we don't have to necessarily lay out the specific testing instruments that have to be used. That's really up to the professional judgment of the person doing the evaluation. But definitely the types of assessment. Is it going to be social emotional? Are we going to be doing cognitive testing, academic testing, speech and language? So all of that is on that assessment plan so the parent really understands what is it that you're concerned about and going to be looking at for my child. And then the assessment plan requires parental consent in writing. And so we have to make sure that we ask that of the parent to consent in writing by their signature and document the date that consent was obtained, because from the date that we get that consent from the parent, our timeline starts ticking to get that assessment done in a timely manner. Sometimes also, you know, people ask me, well, gosh, it sure seems like parents and students with disabilities have a lot of rights, but do schools have any rights under the IDEA? Assessment is one of those areas that we have rights in. So we can't offer a child an appropriate program unless the parent has allowed us to do an assessment and really determine what the child's needs are. So we have lots of rights when it comes to assessing the child. We get to select who does the evaluation, what kind of test instruments are we going to be using. You know, the parent doesn't necessarily get to dictate all of the conditions on the assessment, and we see that a lot. Maybe a parent will say, I'll consent to the assessment, but I only want this person to do it, or I want to be in the room when it happens. And, you know, that's really, you know, up for discussion. We always want to communicate with parents about, you know, well, what would make them comfortable to allow us to move forward. But our assessors really have the ability to say, no, that really impacts the validity of the test if you're in the room, Mom. So, you know, we're not going to allow that. So that's not consent if you don't consent to do it the way that we need to do it. The way they can challenge it if they don't agree with the outcome of the assessment is they can file a due process complaint. They can ask for a second opinion by an independent evaluator if they don't agree with the outcome. So that's how you challenge it. If they don't think we've done a good job with the assessment, there's ways that they have for recourse for that. But they don't necessarily get to dictate how we do our evaluation. It also includes the right to request, like I said, the notice of procedural safeguards. So this is that parents' rights notice that's, probably about 10 pages thick, that at every IEP meeting we make sure we provide it to the parents, or at least we ask the parents if they would like a copy of their procedural safeguards. And it contains everything that parents are supposed to know about what their rights are under IDEA and what their child's rights are. So we have to make sure that we provide this notice to parents at least once a year, but always upon that initial referral, or whenever a parent requests an assessment. We have to make sure we give them those procedural safeguards. That's very, very important. Also, within those procedural safeguards, it tells parents that they have a right to request an independent educational evaluation at public expense. So parent, if you don't agree with the evaluation that we just did with our child, we will pay for an independent evaluation of your child if you disagree with our assessment. Or they have a right always to go out and get their own private assessment at their own cost, and then we would have the obligation as an IEP team to review that information as a team, and at least consider whether or not that there's any information in there that's helpful to the team. So when should prior written notice be provided? Has any of you heard of this thing called prior written notice? I know some of you have been in my trainings before, so I hope at least a few of you have heard of prior written notice. Yeah, okay. So prior written notice is this requirement in the law that we provide parents with prior written notice before we implement it, of anything that the school district is proposing to do or refusing to do. So we have to make sure that we provide this prior written notice to parents whenever we're initiating or changing the identification of a student. So that's that referral process. Whenever we're initiating or changing evaluation of a student, so that's that assessment plan that I was talking about, we would provide the parents with written notice. Everything needs to be in writing so they can see it in black and white, what is actually being proposed. Anytime that we initiate or change the placement of a student, or really anytime we're changing the provision of a free appropriate public education. So that means really anything in the IEP. If we're changing goals, if we're changing services, the amount and frequency of those services, transportation, anything that's within the IEP is part of FAPE. And so if we're making changes to that, we are obligated to provide the parent with prior written notice before we implement those changes, that here's what we're proposing to do or what we're refusing to do. So there are 7 things that have to be included in prior written notice. Again, within the special education information system, there's a prior written notice form that can be very helpful, that makes sure that you cover all 7 of these components. But the big thing here really is, not only are you describing what the action that you are proposing or refusing to do, but the why. An explanation of why the school is proposing or refusing to do the action. So that can be really important. So if, for example, if you're proposing to evaluate a child for special education eligibility, the prior written notice is where you explain to the parent why. Maybe it's because we've been seeing an increase in behaviors in their child, and we've seen a decrease in their standardized test scores, or their grades are declining, or we're seeing problems with attendance that are impacting their education. So it's the why that becomes really important in prior written notice, to help the school explain to the family why it is that we're proposing to do or not do something. And then also the rest of the 7 items here, it also includes sources for the parents to make sure that if they have any questions about what their rights are, here's who you call, here's who you contact, any other options that were considered. And so all of this is going to be in that prior written notice form. It's going to be really important to include that with any assessment plan that we send to the parents so they understand why. So the assessments really are the foundation on which an IEP is based. So whenever I get a special education due process complaint, one of the first things I say was, when was the last assessment? Who did it? Is it good? Did we do a good job? Did we assess in all areas of suspected disability? And a lot of times people say, well, I don't know, I didn't even look at when the last assessment was. Well, okay, that's where we start, because that assessment really sets the foundation for the whole rest of the IEP. If we don't have good assessment information, that's the data that we can build a child's IEP based on that assessment information. So the assessment really becomes so critical in that whole IEP development process. So the timing for assessments, they have to take place before the initiation of special education services for a child. So that's that initial referral into special education. We have to make sure we've done an initial assessment of the child. Reevaluations must take place at least once every 3 years. So that's what's known as the triennial evaluation. So at least every 3 years, we take a look and say, yeah, does this child need to have a reevaluation? Maybe, for some students, we don't need to look at cognition if that hasn't really changed, but we want to kind of take a look and get an update on their academic abilities. So it really depends, but we're really looking at it on a 3-year cycle of doing that updated information so we get the best and most current information about the student's needs. So our obligation is to make sure we do it every 3 years unless the parent and the school district agree that we don't need to. So that's really kind of an IEP team conversation about, we don't really think we need updated information right now, so there's always possibility that there could be agreement. But for the most part, these reevaluations are really critical to get that updated information every 3 years. Not more frequently than once a year. So the law talks about how we don't have an obligation if we just did an assessment last year and the parent's asking for another assessment 6 months later. We don't have an obligation to do one more frequently than once a year. And really, who would want to do that to a poor kid, to have them reevaluated more than once a year? So we also have an obligation to make sure we're reevaluating when the LEA determines that the needs of the child warrant an evaluation. So even if it's in between that 3-year cycle, if we think, gosh, we're seeing some changes in the student's needs here, so we want to propose another evaluation, even though the triennial is not due for another year or maybe 2 years, but maybe some sort of circumstances have changed. Maybe there's been a new recent diagnosis. So again, that's our obligation to refer the child for another reevaluation whenever we're seeing challenges. And then we also have the ability to do assessments at parent or student in the case of an 18 or older student at parental request. Anytime that they believe that a reevaluation is appropriate, they can ask for it. And then it's really up to the school district to decide whether or not we think it's appropriate or not. If not, we can provide them with prior written notice that says we don't believe that a reevaluation is warranted at this time. But if it is, we start the process. We send them that assessment plan, wait for us to get the written consent back, and then we move forward. So our obligation to make sure that we're assessing in all areas of suspected disability, that includes all of those laundry list of areas, health and developmental, vision, hearing and language function, social emotional, general intelligence, academic performance, communicative status, motor abilities, self-help, orientation and mobility. All of those areas, the IDEA has said specifically we have to make sure that we address all of those areas if they're appropriate for a particular child. A lot of times the health and developmental information, it might not change. So for example, we may ask parents, well, was the child, full term? Was it a cesarean birth? I mean, all of those kinds of things. That information is probably not going to change over time. So that historical information, usually we can just gather one time as part of that initial assessment. But maybe over time, a child's medications have changed. And so when we do those reevaluations, we're going to want to get that updated health information from the parents so that we have the most current information and the best information that we can on the kid to help us make decisions. Same with hearing and vision screening. So we have to make sure with every triennial evaluation and initial evaluation that we've done current hearing and vision screening. And so I know at certain grade levels, all general education students, unless their parents have opted out, go through that hearing and vision testing, and so we can report those scores if they're updated in the IEP team as part of the evaluation so that we have that hearing and vision information current as part of the evaluation. So one of the ways to make sure that we have assessed in all areas of suspected disability is to have a multidisciplinary team draft that assessment plan. So a lot of times it might just be the special education case manager or the school psychologist that drafts the assessment plan, but the problem is that we might miss something. So if we don't have multiple people have input from the school side of things into what that assessment plan should really be looking at, we might miss something. So maybe somebody does an assessment plan and we're looking at academics and cognitive and speech, but we didn't realize that behavior was a problem because we didn't have the input from the general education teacher into that assessment plan. So having multiple people have input into that assessment plan can be really important, so we make sure we've covered everything, because sometimes we might only get one shot at it. And if we've missed something, that's going to come back, and either we're going to be funding an independent evaluation if we didn't do a thorough job on the evaluation, or a parent could file for due process and ask for compensatory education services or reimbursement if they had to go out and go get an assessment on their own because we didn't do our job in assessing all areas of suspected disability. So just a little practice tip to make sure you're providing that input into the assessment plan. So here's, again, just kind of a list of issues that could give rise to a suspected disability. Is the pupil struggling academically? Has the parent expressed concern verbally or in writing? Has the teacher or service provider expressed concern either verbally or in writing? Maybe the student's receiving services outside of school. So that, again, might be enough for you to kind of be thinking, do we need to assess this kid? Parent told me that they're getting speech therapy services outside of school, or they're receiving counseling services outside of school. So is there enough for a suspected disability here for at least to make the referral? Parents don't have to agree to the assessment plan if they don't want to, and at least we've met our obligation to refer the child for an evaluation. But if they say, no, thank you, not interested in special education, then at least we've met our obligation to ask and to make that offer. So remember that the threshold for suspected disabilities is extremely low. I'll give you a little example of how kind of child find and not assessing can come back to bite you. I just was dealing with a case which we had to settle on behalf of a school district. The student was a freshman in high school and had gotten A's and B's at a private school, just did phenomenally. And towards the end of the freshman year, he started having some mental health issues. During the summer, ended up being diagnosed with anxiety and depression. Couldn't really cut it at the private school anymore, so the student came back to the local high school district for his sophomore year, and the parent said, gosh, my kid's really been struggling with some mental health issues, anxiety and depression. He's refusing to go to school right now. What can we do? What can you do to help us? And so this is what they're talking to the general ed side of the house. And general ed folks said, we've got this great independent study program. It's just like, we have lots of kids just like this student, anxiety and depression and, really kind of struggles with being on a big campus. So we've got this independent study program. And the parent said, okay, well, we'll give it a shot. We'll see how it goes. Fast forward to January, right? So the kid started in the fall. Kid never even showed up at all fall. Never showed up to work with the teacher, didn't turn in any work. There had been no communication with the parent to say, hey, where's little Johnny? Johnny hasn't been coming to school. What's going on? The parent, in December, the student unfortunately tried to commit suicide, and unsuccessfully, thank goodness. But really was struggling with some mental health issues. It wasn't until January that the school finally sent an email to the parents saying, gosh, we haven't seen Johnny. What's going on? We haven't seen him at school. March, we get a letter from the parents saying, we're going to unilaterally place our child in Utah in a residential placement facility, and we want you to pay for it, school district, because you dropped the ball. We've been telling you since we enrolled him in the fall that he's having mental health issues, and we need you to help. But we hadn't done anything. Kid hadn't been going to school. March, now he's in Utah. So March is when the special ed team finally is like, wait, who's this kid? I've never even heard of this kid before. So now they're on the special ed radar screen. They got the assessment plan going. But of course, now we're into the summer, right? And so the assessment doesn't get done until we get back into the fall. Finally, in September, there is a very good IEP offered for the student, very rock solid, but a due process complaint gets filed because of that child find issue. So the fact that nothing really was done to refer the child for a special education evaluation from the start of his sophomore year until March, and then we didn't offer anything in terms of a program until September, the school district felt it was really in their best interest to settle this case, because again, that opens you up to not offering to assess, not assessing in all areas of suspected disability. Maybe if we had done something sooner, we could have not only helped the student sooner, but hopefully avoided litigation in that case. So I just wanted to share that since it was fresh on my mind. So in terms of making sure it's sufficiently comprehensive, again, the evaluation needs to make sure it identifies all of the child's needs for special education related services, whether or not commonly linked to the disability category in which the child has been classified. So it could be that a child has eligibility under the category of specific learning disability. So we know that there's some sort of processing disorder, some weakness in math or writing, something along those lines of a specific learning disability. But we don't just look at that. If we're also seeing concerns in the area of behavior or social emotional or attention, our obligation is to be looking at all of those areas of need, not just the learning disability. So once you're in special ed, you're in for all intents and purposes, and we got to make sure we're addressing all areas of need, regardless of whether it really is like a classical learning disabled student or a classic, speech and language situation. So one case example, talking about a sufficiently comprehensive evaluation, parent of a child with autism requested an evaluation and submitted parental input stating that her primary concerns were that the child did not speak, had sensory integration difficulties, and was extremely sensitive to new food textures, and thus was a very picky eater. The child tended to flop on the floor when he missed a snack at school. I do the same thing. The LEA assessed the child's social, communication, motor, OT, self-care, and cognitive skills, as well as adaptive behavior. The evaluator did not address the feeding issue other than remarking that it was not educational in nature and should be addressed medically. The evaluator recommended a speech evaluation. The parent sought an independent educational evaluation at public expense, arguing that the evaluation was not broad enough, hadn't covered all of those areas. And the hearing officer here determined that the parent was entitled to an independent evaluation because the school district's evaluation did not address those feeding issues and those speech issues. They just said, well, we would recommend a speech evaluation, but why wasn't it done initially as part of that assessment plan? So that's probably a problem. If somebody was paying attention, we would have flagged that speech area initially as part of that initial assessment. As part of the evaluation, the IEP team and other qualified professionals need to make sure we're reviewing existing data that we already have as part of that evaluation process. So doing a thorough records review is going to be really important for the evaluation, including information that's provided by the parents. So we really want to make sure if the parents have gotten some sort of outside report from a doctor or a therapist or something, that we use that information to the extent the parents have provided it to us and shared it with us. That's got to be part of the conversation that we're analyzing that information. Also, to make sure as part of the evaluation, we have current classroom-based local or state assessments and classroom-based observations. This is really important when we do evaluations, that the evaluators actually observe the student in the classroom environment. That's really important. A lot of times parents might go out and get some sort of independent evaluation. The kid and the family will go to the school psychologist and they'll sit there and spend some time and do a bunch of testing, and then we'll get the report, and I'm sitting there usually across the table from this evaluator, and I'll say, oh, well, did you come observe the child in the educational environment? Well, no, but they were in my office for like 2 hours, and we had all kinds of interaction. And Okay, so you didn't get to see the child in the classroom environment, you didn't get to see them interacting on the playground, you didn't get to see how they transition from class to class, you haven't reviewed the student's educational records, you didn't talk to any teachers. How are you going to make recommendations about the child's educational program? That's going to be really tough. So it becomes really important for our folks to do a good job of doing those classroom observations, or if we see issues on the playground or during those transition times, we want to observe those and document that we've observed that as part of our evaluation. And of course, observations by the teachers and any related services providers, that's all going to be really important information for the evaluation. So a lot of times when we're doing the evaluation, the folks that are doing the evaluation will talk to the providers, talk to the teacher. What are you seeing in the classroom? Not only are they going to see it themselves when they do the observation, but we want to get more historically, like what are you seeing? What's he doing well? What's he not doing so well at? Does he have friends? Those kinds of things, all real important for the evaluation. The evaluations and information provided by the parents and other sources. So again, we want to make sure we're considering, we don't have to agree with it, but at least considering information that the parents have provided from outside folks. And think about whether or not we need to ask for permission from the parents to be able to exchange information with those people. So sometimes we might get the parents to give us a letter from a doctor saying, gosh, you know, our child has XYZ diagnosis and, you know, needs certain things. In order for us to really be able to communicate with that doctor, if we offer to the parents a form that says, will you agree to allow us to talk to your doctor so we can get a little more information from your child's doctor? That can be really important as part of that evaluation process. Again, so we've at least asked. Again, if parents want to say, no, I'm not going to let you talk to my kid's doctor, that's their prerogative to do that. But at least we've asked, and we want to document that we've asked to be able to do that, to have good information. We want to make sure that all of the tests and instruments that are used as part of the evaluation are valid and reliable, and so we have to make sure that they are used for the purpose that they were intended to be used, that we actually follow the instructions from the test publishers in doing the assessment, and if the assessors deviate from those instructions in any way, we would want to document that in the assessment report, and making sure that we're also assessing the relative contribution of any cognitive behavioral factors in addition to physical and developmental factors. We also have to make sure that they're properly implemented when we're doing the assessment, so we want to be very careful in following the procedures. And this comes up in the context of due process. So if we have somebody who's done an assessment, I've seen it where a school psychologist will be on the witness stand and literally those test protocols are being opened up and those score sheets, and the student's attorney will be asking, well, why did you score him here, but you didn't give him credit for this answer over here? And so we really want to make sure we're following those test publishers' instructions, because later on it could really come back to bite you if you haven't followed the procedures. So maybe someone will argue you didn't do a very good job on your evaluation. Also, that the assessment has to be provided and administered in the child's native language. There was a Supreme Court case that came out before the IDEA was changed that talks about if a child is Spanish speaking and you evaluate him in English, you know, that's not going to give you the kind of information that you need in order to develop a program for the child. So we have to make sure that we are evaluating in the child's native language so that we are really getting a good sense of what the child knows or doesn't know, what those skill deficit areas are. So another case example, here a hearing officer ordered a school district to pay for a 13-year-old with ADHD to undergo an independent evaluation because the district's errors in the administration and scoring of an academic assessment made the evaluation unreliable. So although the test protocols required the district to establish baseline and ceiling scores for the student, the district's evaluator failed to do so. The evaluator also gave the student full credit for 3 writing samples that were grammatically incorrect. The district's assessment of parent and teacher comments was also lacking. Not only did the district use the short form of a parent and teacher questionnaire to evaluate the student's behavior, but it diminished reports of markedly atypical behavior by averaging all of the responses. So the district failed to consider the student's prior record of behavioral problems of head injuries that he had suffered as a child. So because of this, the school district wasn't able to prove that they had done an appropriate evaluation, and then they ended up having to pay for the parents to get an independent evaluation. We want to make sure we're using a variety of assessment tools. That's really the key with assessments, is that we can't just rely on one test or one observation or one report card to say whether or not the kid's in special ed. You really have to use a variety of different factors when looking at special education eligibility. We really can't use just one test as the sole factor. We have to make sure that we have a written report of the assessment results that we provide to the parents. It has to include all the results of the assessments that were administered. And then we have to make sure we provide copies of the assessment report at no cost to the parents upon completion of the assessment. So sometimes parents will say, you have to give me that assessment report at least 10 days before the IEP team meeting, otherwise I'm not coming. And I don't know, where they got that information. What the law says is that it has to be done upon completion of the assessment. Now, sometimes upon completion is midnight before the IEP team meeting. So that's our obligation, though, is to make sure we get it to the parents as early as we can so that they can be good participants in the development of their child's IEP. It doesn't have to be a certain time period, but if the parents say, hey, I really want this a couple of days ahead of time so I can process the information before I jump into an IEP team meeting, we want to try to accommodate that. I understand sometimes that's just not possible, but it also really helps the IEP team be more productive. So rather than sitting there in an IEP team meeting and listening to somebody read their 16-page psychoeducational evaluation, if the parents have already been provided it ahead of time, they can read it, bring their questions, and you can just kind of hit the highlights when you're actually going through it in the IEP team meeting. Makes things go much faster. So then we get into the actual IEP process, and we're going to go over some of the details of that. So from the time that we do our assessment, we have to make sure we've developed an IEP for the child based on that assessment within 60 calendar days. So all throughout the IDEA and the Education Code, you'll see sometimes we use calendar days, sometimes we use school days, sometimes it's business days, which is really weird because we're in school. But so assessments, 60 calendar days. If it doesn't say school or business, assume it means calendar days. But with the IEP timelines for developing them, there are some breaks in there when we have school vacations in excess of 5 days. So the timeline kind of stops and gets suspended like during summer break. If you get an evaluation, if you started in the spring, that timeline stops and then you finish it up in the fall. So there are some kind of tweaks to that timeline, but for the most part, we have 60 days to develop the IEP. We also have to make sure that we periodically review the IEP at least annually. So we have to make sure at least once a year we are sitting down with that IEP team and we are reviewing the student's IEP. We're taking a look at, has the child made progress toward their goals that we developed last year? Has the child been making progress in the general education curriculum? And so we also want to make sure we're developing new goals for the child on an annual basis, hopefully. So at least annually, we want to make sure we are meeting. In terms of the IEP meeting notice, we want to make sure that when we are scheduling IEP meetings with parents, that we give them an IEP meeting notice early enough to afford them an opportunity to attend. So again, there's no hard and fast rule about what that is. For some families, that might be 5 days prior to an IEP meeting. For me, with my crazy calendar, 5 days would not be enough to get me to an IEP meeting. So I'm talking, 2-3 weeks to probably find some time on my calendar in the middle of the day. So you want to make sure, depending on the family, that we give them that IEP meeting notice far enough in advance that we are making sure we're meeting our timelines as far as having our annual meetings and our triennial meetings, but to make sure that they'll be able to attend. We also want to make sure that we list on the IEP meeting notice who's going to be attending, not by name, but by position. So is the speech therapist going to be there? Is the principal going to be there? So that's totally fine if we just list the position so the parent has some idea of who's actually going to be at the meeting and what's the purpose of the meeting. We want to make sure that if the part of the reason to be meeting is because we're going to be talking about transition services for students who are 16, that we're starting to talk about post-secondary issues for students, that has to be noted on the IEP meeting notice so that the parents know that we're going to be starting to talk about transition. Also to make sure the parents know that they can bring other people to the IEP meeting. So if they want to bring Uncle Bob, they think that Uncle Bob has some special expertise about the child, get another chair. So they can bring whoever they want that they think is appropriate. Maybe it's an advocate, maybe it's an attorney to an IEP meeting, which in that case, I'd probably be there too. So we want to make sure that the parents understand they have the right to bring other people to the IEP meeting that they think can provide information about the child. The IEP also has to make sure that it's mutually agreed upon time and place. So a lot of times there's a lot of back and forth with parents about trying to find an agreeable time that works for our team and works for them. But we have to hopefully mutually agree upon that date and time. So who has to be at IEP meetings? So there are certain mandatory members of IEP teams. That is one of those procedures that we talked about, that if we don't meet that prong of providing a child an appropriate education can get us into trouble. So certain people absolutely have to be there at those IEP teams unless they've been excused, and we'll talk about that in a second. So first, parents, of course, right? We want to make sure that the parents are there. However, if a student has turned 18, all of the rights of the parent shifts to the student, the adult age student. So they have all the rights to attend their IEP meetings, to sign their IEPs, to sign assessment plans, if we're talking about a student who is 18 or older. But other than that, the parents need to be there. We have to have at least one general education teacher of the child if the child is or might be in a general education environment. So that becomes really critical to have that general education teacher present at the IEP meeting. We also have to have at least one special education teacher of the child, where appropriate, no less than one special education provider of the child. So if we're not talking about a teacher, it could be some other related service provider that has to be at the IEP team meeting. We have to make sure that there is a district representative there, so somebody who is there who has the authority to speak on behalf of the school district. This might be the site administrator, this might be someone from the district office, but whoever it is, this person has to have the authority and the knowledge to be able to talk about the general education curriculum, that they know what the availability of the various programs and resources are within the district. That's really critical to make sure that we have that at every IEP team meeting. We have to have an individual who can interpret the instructional implications of any evaluation results. So if we have a parent who's bringing a private speech and language therapy evaluation, we need to make sure we have our speech therapist there so that they can help interpret those results for the team, and we can really make sure that everybody understands what those results mean. And then again, at the discretion of either the parent or the school district, any other individuals who have some special expertise or training or knowledge about the child. So maybe you know transportation is going to be a big topic at an IEP meeting. Might be important for us to have the transportation folks there to kind of talk about transportation issues. So it's really up to us who we want to have from the district side. It's up to the parents to bring whoever they think is appropriate. And then whenever it's appropriate, maybe the child. Maybe it's appropriate to have a child. Sometimes maybe it's appropriate to have the child there for part of the IEP meeting, but not all of it, if there's going to be real sensitive information that's discussed. So that's really up to the IEP team and the parents to decide whether it would be appropriate to have the child there. We have a duty as part of the parents as being a mandatory member of the IEP team. Our obligation is we have to try to convince the parents to attend. So we get the question on occasion, well, gosh, we keep trying to schedule this meeting and the parents keep canceling it. can we just go ahead and have this meeting without the parents? Well, we maybe, that's a maybe answer from the lawyer. We can only have an IEP meeting without a parent if we have documented reasonable attempts to convince the parent to attend. And the law actually talks about what are those reasonable attempts. So we have to have detailed records of phone calls, letters home, emails. We have to even have records of visits that we've made to the home. So if we've sent letters and we've sent phone calls to the parent and they're just not responding, we even have the obligation to maybe go show up at their house and say, hey, here's an IEP meeting notice. We really need you to be there. You're important to your child's IEP. We have to document our attempts to do that. If and only if we've done that, then we could move forward with holding an IEP meeting without the parent. But we really want to proceed cautiously because the parent is a real critical member of any IEP team meeting. And also, we have the ability to use alternative means of participation in the meeting if that's helpful to the parent. So maybe the parent can't get out of work. They've used up all their vacation for whatever reason. And so we can even say, hey, how about you join on the phone? And you can participate that way, or some sort of Skype or video conference capability. So as long as the parent's participating, we can even use technology to help out with that. So excusal of IEP team members. So as I mentioned, we went through the list of who has to absolutely be there, but we can excuse mandatory members of the IEP team if the member's area of curriculum or related services is not being modified or discussed at the meeting. The parent and the LEA must agree in writing that the member's attendance, either in whole or just part of the meeting, is unnecessary. But if you are going to be talking about that IEP team member's area of curriculum, the parent and the LEA must consent in writing, and we have to make sure that that person submits in writing to the parent and to the team input, some sort of written report into the development of the child's IEP. So only then can we excuse one of those mandatory members if the parent agrees. If they don't agree, they're not excused and they got to be there. So we have to make sure that all of this is done in writing. And also to make sure if we are suggesting to excuse somebody, that we give parents as much notice as possible that we are looking to excuse somebody from the team. So maybe a general education teacher is not going to be able to be available. You've already got everybody nailed down for the time and date of the meeting. We want to try to let the parents know as early as possible, hey, the general education teacher is not going to be there. Are you okay with us proceeding without this person? We want to get that in writing from the parent. Say, hey, the general education teacher is going to put something in writing to the development of the team. But if the parent says, no, I'm not okay with that, then we're going to have to reschedule for a time when the general education teacher can be there. Because, again, they're a mandatory member, and you have to have both sides agree that their presence is not necessary. Along with that, we want to really make sure, one of the things I get to talk a lot with attorneys who represent students and families, and one of the things that is like nails on a chalkboard to them is when members of the IEP teams are coming and going out of the IEP team meeting. So, nothing says to a parent faster that what we're doing for their child isn't as important as something else that you've got to be doing as having people coming in and out of meetings. I'm just going to pop in real quick, give my report, and then I got to get back to class. Those are really challenging for parents to have to deal with, and can certainly get us into litigation. So we want to really try to avoid that as much as possible, because those mandatory members of the team, it means the development of the IEP really means from start to finish. Not just to pop in and give a report about how the kid's doing, but to be there for the development of goals and for services and to talk about placement. So for example, the law specifically talks about how important general education teachers are to the development of the IEP. The law says gen ed teachers must help decide appropriate behavior strategies and supports for students. We have to have them help us figure out supplemental aids and services and modifications and any supports for school personnel. So specifically, the IDEA calls out general education teachers and how important they are to this process. Also, we want to make sure that mandatory IEP team members, when we're talking about post-secondary transition planning, that we have to invite the student to attend the IEP meeting. So in some cases, it may or may not be appropriate to have the child there, but if we're going to be talking about transition, we have to invite the student. At least invite. Student doesn't have to be there, but at least we want to document on that IEP meeting notice that we have invited the student. If the student does not attend, then the district has to make sure that we have done whatever we can to make sure that the student's preferences and interests in terms of transition planning, post-secondary goals and that sort of thing, at least we want to figure out a way to incorporate that student's input into that process. Also, the district must, with parental consent and to the extent appropriate, invite any representative from any public agencies who might be responsible providing and funding those transition services. So it might be appropriate to invite the Department of Rehabilitation to a student's IEP meeting when we're going to be talking about transition services, because it could be that they're eligible for providing some support or funding for that student later on. So in terms of informed consent and translation, the IDEA requires school districts to take any and all necessary action to ensure parents understand IEP team proceedings, including arranging for interpreters. So we have to make sure when we have IEP team meetings that we've planned ahead, and if we need to have an interpreter there, and that's for both non-English speaking families and deaf families as well, if we need sign language to be there so that the parents can fully participate in that IEP process. We also want to make sure in terms of translating IEP documents, so the law talks about that the parent has been informed of all information relevant to an activity for which consent is sought in his or her native language. As well as there's a California regulation that says IEP documents must be provided to the parent in his or her primary language upon request. So we have to make sure, again, that parents can't sign something that they don't understand. So we have to make sure that we are getting those documents translated so that they really have the ability to participate in the meeting and to be able to consent or not consent to the IEP paperwork. How are we doing on time? Check. 1:45. Oh gosh. Okay, we're good. We're doing good on time, but I just completely screwed everything up here. Help me out, Carol. Sorry, we went back to the beginning. We're going to have to do that over again. All right, let me jam through. Excuse all, okay, so making sure that we ensure meaningful parental participation. As we talked about, parents are a critical member of their child's IEP team. They are equal participants. They don't have a veto power in the IEP. So it really is supposed to be a consensus process, and that's what we're always working to do in IEP team meetings, is to get everybody to try to reach consensus, which I know can sometimes be easier said than done. But we have to make sure we're at least considering the parents' input and concerns and documenting in our IEPs that we've at least considered things that parents are bringing up. But ultimately, if we're not able to reach consensus, it's really up to the district to say, we've heard you, we understand your concerns, we have a difference of opinion, that's going to happen, and here is our offer. Here's what we are offering to your child, and then it's really up to the parent whether or not they want to agree or not. And they have certain legal recourse that they can take if they don't agree with the school district's offer. So a little bit about the actual content. So we talked a lot about procedures. The content of the IEP has some procedural aspects as well. So the first thing, and again, all of this is going to be driven off of the assessment information and the information based on observations and teacher input. What are the child's present levels of performance? I heard somebody call them plops one time, which I just think is awful. But that's apparently an acronym you can use for present levels of performance. So what we have to have in the IEP is a statement that includes the child's present levels of academic achievement and functional performance, including how the child's disability affects the involvement in the general education curriculum, and as well as for preschool children, how the disability affects the child's participation in appropriate activities. So a big thing for your present levels is, again, this kind of sets the foundation. You have your assessment information, and everything is going to be built off of this. If you don't have good present levels, where the kid is right now, how are you going to be able to draft goals about where we want the kid in 1 year? So having good data to support that present levels of performance is really, really important. It's especially critical when we have incoming students. So if you have a transfer student coming into our district, a lot of times we'll take a look at those present levels on that IEP and just, well, they just had an IEP, 3 months ago at the last school district, so we'll just assume those are good. That's our kid now. So we have to make sure that if we look at that IEP and we say, gosh, this isn't really what I'm seeing in the classroom as far as where they're at right now, maybe we need to do some more assessment and figure out where the kid is right now. So really we want to make sure we don't assume anything about incoming IEPs for students. And also having work samples at IEP meetings I think can be so valuable. It really helps you be an effective IEP team member. If you're able to sit next to the parent and say, here's what Sarah was doing at the beginning of the year, here's what Sarah's able to do now. That could work in both ways. It could show how much progress Sarah has made, or it could show, Sarah's really struggling here, and so we need to have some more support for her. So having those work samples is concrete data that we can use, that parents understand, that you can develop present levels of performance from. We also have to have a statement of goals. The goals are what we are evaluating where a student has made progress or not on those goals in all areas of need. We want to make sure that the goals are measurable. That's one of the things that we see in due process complaints a lot, that you might have goals, but there is no way you're going to be able to measure that in a classroom. So without having good baselines, it's really hard to tell whether or not the goal adequately addresses a student's needs or whether the progress can be accurately evaluated. So baseline information that just merely restates a child's need to develop skills doesn't really provide IEP team members with the sufficient information that they need. So I'll give you an example. So baseline information where the IEP says, student has difficulty completing assignments and turning them in on time. Anybody ever seen a baseline like that? So what percentage of time? Are we talking once a day, once a week? Are we talking homework assignments or classwork? Are we talking which classes? The kids in 6 different classes. Are we talking all classes? So another one is student has trouble with peer-to-peer interactions. What kind of trouble? How often? In what environment? Are we talking about initiating peer interactions or responding to peer interactions? So we want that baseline information to be as specific and detailed as possible. So that way we really can see, I can't see what difficulty is. I can't measure that. I can't measure trouble or difficulty. So baseline information also that just restates a child's assessment scores, and then there's no tie in the goal of what those assessment scores are. So maybe we have a baseline that says student scores on the test of language competence yielded a standard score of 65, and then the goal is a very lovely goal, but it has nothing to do with the baseline. So there's no link. There's no link between the baseline and the goal. So one of the ways that I like to shortcut IEP goal writing is cutting and pasting. If you take the baseline information, so for example here we have a written language goal, and it says currently when given a visual model of a sentence starter containing no more than 2 words, Sarah can write or type a 5-word sentence with no more than 3 verbal prompts from staff in 0 out of 10 trials. You take that language, drop it into the goal, and the goal is to be able to do that in at least 7 out of 10 trials. Then it's very measurable. Where she's at right now, she's at 0. We want to get her to 7 in 1 year. So it's very measurable, very easy for folks to take data on this kind of a goal and for us to be able to say, yep, she's doing it or she's not, or she's halfway there with a little more work, that kind of thing. So making sure that the baseline and the goal are linked up can be really, really important. We also want to make sure that we take account for our English language learners when we are developing our IEPs, including our goals. So we have to make sure our IEPs include information about the student's current level of English language proficiency in listening, speaking, reading, and writing, indicate how the language proficiency needs of the student will be assessed, and include goals and objectives that are linguistically appropriate, is the language that is used for writing goals for English language learners. So we want to ensure, for example, that the goal states specifically in what language the particular goal and objective are going to be accomplished. So that way it's very clear to the team how we're going to be measuring this, and are we measuring it in English or are we measuring it in another language for the English language learner. And if it would be appropriate to the student's level of linguistic development and proficiency in that language. So we want to make sure that it's appropriate and at their level, considering their level of English development. As we talked about earlier with assessments and making sure that we're evaluating in all areas of suspected disability, same goes for development of an IEP. So, you know, we're not going to talk too much about discipline today. That could be a whole day-long presentation talking about discipline for students with disabilities. But suffice it to say that IDEA has given us a little more flexibility with being able to discipline students with disabilities. But on the other hand, they've taken a more proactive approach to behavior. So before we get to the area where we're having to suspend or potentially expel students with disabilities, the law is saying we need to be addressing those behaviors in the IEP before we even have to be talking about suspension and expulsion. So for every student with disabilities where behavior is impeding that student's learning or learning of others, we have to be, as an IEP team, talking about those behaviors and figuring out positive strategies, whether it's through a goal or developing a behavior intervention plan for the student, whatever the IEP team thinks is appropriate to try to address those behaviors so we're not getting into the discipline nearly as much. So what kind of behaviors am I talking about? It's not just the kind of behaviors that are going to trigger a referral for a suspension or even expulsion. It's not just dangerous behavior or violations of the school's disciplinary policies, anything that interferes with important teaching and learning activities. So it could be the kids falling asleep at school all the time, or some sort of self-stimulating type of behaviors. So any behaviors that are impeding learning, or if it's bothering other kids in the classroom, that's a behavior that the IEP team needs to be taking a look at. We also have to have in an IEP, and this is right on your IEP forms, of how are we going to be measuring progress on goals, and how are the parents going to be informed of their child's progress on goals. Typically, we do progress reports on our IEP goals. It either can be in conjunction with report card time, but it doesn't have to be. It could be some other cycle. But we have to make sure that we include that in the IEP of how are we going to be letting parents know about progress on goals. And then we got to make sure we actually put that together, that we actually do those progress reports on a quarterly basis or whatever has been agreed to in the IEP. We also have to make sure that we include on the services page. This is where we talk about including a statement of all of the special education and related services and supplementary aids and services that a child requires. So if we have the services are what we need in order to be able to implement the goals. So that is going to all be on the services page. So for example, we want to include a description of any specially designed instruction and specialized physical health services needed for an eligible student with under the other health impairment category who might have diabetes. So if we have a student with diabetes who's eligible under other health impairment, we have to list on that IEP, okay, well, what kind of supports are they going to need in order to address their medical concerns, that sort of thing. We also have to make sure that the IEP includes a statement of the program modifications and supports for school personnel that will ensure that the child can advance appropriately toward attaining their goals, that they can continue to make progress in the general education curriculum, and to be educated and participate with other children with disabilities and non-disabled children as described in this section. As part of the services page, we have to make sure that we include very specifics about the frequency and duration of those services. My senior partner always jokingly says, we want to know the wattage of the light bulbs on the IEP and the color of the paint in the classroom. I wouldn't quite go that far, but it does need to be specific. So we know who is doing what, when, how frequently. Are we talking on a weekly basis? How many minutes? If we're talking about consultation or collaboration services, be specific about when it's needed, because that's the IEP team, that's your job, is to figure out when it's needed. So one of the concerns that we see a lot of times with services and supports is where people will write in that they are required as needed. So that could be never or always. And it's not clear to the parent what's being offered. So if you're offering certain types of supports and services on an as needed basis, that's really the IEP team's job, is to figure out when it's needed. And if you just write in as needed and kind of leave it up to the person who's supposed to be implementing it just to figure that out, that's going to make it really hard to implement and very hard for the parent to understand whether or not you're doing what you're supposed to be doing or not. So we want to really be specific. So to the extent that a child is or is not going to be participating with typical peers, that has to be stated in the IEP. So that's the section of the IEP where we talk about the percentage of time that the students in the general education environment or being pulled out of the general education environment. Let's see. Accommodations for assessments. So there is a page in the IEP where we have to be talking about if the child is going to be taking our standardized assessments, the SBAC, that the IEP includes a statement of any individual accommodations that are necessary for the child to participate, or if the IEP team has decided that they're going to take some sort of alternate assessment, we need to include that information on the IEP as well. As far as transition services, so beginning not later than the first IEP to be in effect when the child turns 16 or younger if determined appropriate by the team, but typically it's done right before the child turns 16. We have to make sure that we're addressing the area of transition. And so those are measurable post-secondary goals based upon age-appropriate transition assessments related to training, education, employment, and independent living skills where appropriate. We also have to make sure that it includes a course of study needed to assist the child in order to address those issues. So a lot of times the services, of course, have to be based on the student's needs. That's why it's really important to invite the student to participate in that IEP. But usually you do your homework ahead of time prior to developing a transition plan for a student. So we are going to be doing assessments that really take into account what are the areas of need in terms of instruction or related services, or what kind of community-based activities does the child need? What are the child's employment goals and other post-school objectives? How about daily living skills? You know, do they know how to get around in the community and take transportation, get a library card, get their driver's license, all of those kinds of things that we need in terms of living our day-to-day life, because at some point students with disabilities, they aren't going to have the school district there to support them in that way anymore if they've either aged out or they've gotten a diploma. So this is really our job to help support them as they transition into the adult world. So effective transition planning requires the collection of relevant, meaningful transition assessment data from teachers, from the student, from the family, getting information about the student's interests, and this can be through both formal and informal assessments, you know, career inventory, aptitude kind of assessments, interpersonal skills, long-term skills for future planning. All of that really goes into that transition planning, and it really should be the whole IEP team that is working to develop that. Extended school year services, so that is an area that we have to make sure that we address for students, whether or not a child requires extended school year services. So, we know when we end our school year, for some students with disabilities, that might not be enough. They might need some additional instruction during the summer to make sure that they don't regress, to make sure that they don't lose any skills. It's not really a time in the summertime for them to be gaining new skills. That's really during the school year. But if for certain students with disabilities, if the team feels like, gosh, without this instruction during this summer, their skills are really going to regress so much that we won't be able to make it up. And so for some students, we have to be offering extended school year services that are provided to the student. So at least discussing it. It could be that you have a conversation about it at the IEP team and you determine that it's not appropriate or needed for a child, but at least you've had that conversation about whether or not it's necessary. So students to whom extended school year services have been offered, again, this is kind of the standard that we take a look at, that disabilities which are likely to continue indefinitely or for a prolonged period of time. And here's that conversation about interruption of the pupil's educational programming may cause regression when coupled with limited recoupment capacity. So that's really the standard that IEP teams need to be looking about whether or not we need to offer those extended school year services. So a little bit more about balancing your educational obligations with the least restrictive environment mandate. So Congress has said you need to educate special education students with disabilities in the least restrictive environment, meaning to the extent you can, they need to participate with their non-disabled peers. So that's basically what the mandate is. So not only do we need to make sure that we're meeting all of their needs, but there is a preference that they be placed in the general education environment. And so if you think about it, when IDEA first was passed back in 1975, only 20% of students with disabilities were being educated in the public schools. So really, students with disabilities were just being pushed out, right? They're like, we don't have the ability, we don't want to deal with those kids. They were not being educated in the in the public schools at all. And so special schools were being set up for students with disabilities. So one of the reasons the IDEA was passed is to bring those kids back into the public schools. They're all our kids, and so Congress had said, we want them educated in the public schools with their general education peers to the maximum extent appropriate for that child. So now, fast forward, about 95% of students with disabilities are being educated in the public schools. So we've done a really good job of meeting that mandate of IDEA to bring students with disabilities back into the public schools. And so we always are having to kind of balance meeting their needs while still making sure that they're being educated to as much as we can with non-disabled peers. So again, full inclusion is not mandated, so the law doesn't say you have to educate kids in general education, but it's a strong preference. And so it's that kind of balance that teams have to do. So one way to handle that is by when IEP teams are talking about where can we meet the child's goals and where can we have the services take place, you always want to start that conversation with their home school in the general education classroom. We start there, and then if the team says, no, we think that they need more support, then you move up to the next level. So that's typically called the continuum of placement options. You start with general ed, homeschool, in the gen ed classroom all day long, and then you kind of work your way up to where maybe you're pulling the student out for certain subjects, to maybe the child needs special education all day long because they need more of a structured environment. To finally, we have the most restrictive placements where we're talking about residential placements or home instruction, those kinds of things where a child's really not interacting with their general education peers at all. But we always start with the general education conversation first. So what that also means is that because of that, that we may have to make substantial curriculum modifications in order to allow the child to participate in that general education classroom. Because the law doesn't require that the child make the same kind of progress as all of the general education students, but if they're making some progress in the general education classroom, that's enough. We've met our obligation to that child to meet their needs. Maybe they could go a lot faster and make much faster progress if they were in special education all day long. But our job is to try to keep them in gen ed as much as we can and to try to support them by modifying the curriculum to the extent that we can. And that's where our special ed and our gen ed teachers are going to have to work very closely together to figure out what that looks like for that child. And then, of course, once the IEP is developed, we have to make sure that we ensure implementation. So special education related services shall be made available to a special education student in accordance with their IEP as soon as possible following development of an IEP. A material failure to implement an IEP is a violation of IDEA. So if a child's IEP says that they're supposed to be receiving a certain amount of services or certain sorts of accommodations in the classroom and they're not being provided, that is considered a material failure of implementing the IEP and can cost the school district to have to provide reimbursement to the parents or compensatory education to make those services up that we have not provided. We also have to make sure that each general education teacher, special education teacher, or related service provider has access to the IEP and is informed of their specific responsibilities. So how we go about doing that at the district level or at the school side level is really up to us. The law doesn't dictate how we let people know, but the key there really is anybody who is responsible for ensuring that that IEP is implemented, you have to know, okay, what is it that I'm supposed to do? If I'm a gen ed teacher, I need to know what are those accommodations and modifications that I'm supposed to be providing to the homework assignments or to the tests and those sorts of things. If I'm a special ed provider, I need to know how many minutes, how often do I need to be doing this? What are my goals that I'm working on? So you have to know that information, and you need to be able to have access to the entire IEP. If you think that's appropriate and you need to actually go see the entire IEP rather than just be informed of what your job is in relation to that child's IEP, as long as you know that there's somewhere you can go, maybe there's a binder in the case manager's office that has IEPs, and you know you have access to it if you need it, then we've met our obligation to make sure that you've at least got access to it in case you need more information. Okay, how are we doing on time? Think we have some time for questions? We do, we have about 10 minutes. Okay, perfect, thank you. Okay, we've got a lot of questions and there's more coming. So I think what we'll do, we'll try to hit a few of these, and then maybe if we're starting to see some themes of the questions, Carol and I can work together to maybe put out some information and email it to everybody so that we make sure we get your questions answered. What if your school district doesn't provide assessments for teachers' input, meaning a variety of assessment tools slide? So again, that's got to be an area that we make sure that we cover. And so I would hope that as a team that we ensure that teachers are being included in the assessment process in terms of providing input into the child's present levels of performance. Let's see, where is SST in your process? That's a great question. So again, we had such a short time. It was so hard. Probably every one of these slides we could have spent 2 hours on. So this was just kind of a drive-through special education 101. But you're right, the special education student study team process is very valuable in terms of identifying areas for the assessment plan. So, and you know, we didn't even talk about Section 504 when we're talking about students with disabilities. We're just focused on IDEA today. But that student study team is going to be important if you're seeing a student struggle and figuring out whether or not general education interventions are going going to be enough, if we have enough data to support that gen ed interventions are working, or if not, then that student study team can talk about, we need to refer the child for a special education evaluation. Okay. Let's see. Oh, good one. If parents are divorced, do both parents need to attend? What if they request 2 separate meetings? Oh, goodness. If parents agree to time and place of the meeting but do not attend, can the meeting continue? So we'll answer the first one first about divorced parents, and do both parents need to attend? So for the most part in California, if parents are divorced, and unless there is some sort of a court order where one parent no longer has legal custody at all, has no educational rights, both parents have equal rights to their child's education. So in those situations where both parents have equal rights, you send meeting notices to both parents. Both of them are invited to the meeting. You can proceed, though. We get disagreements between parents, believe it or not, when they're divorced especially. You can proceed. So I've had situations where maybe we're offering an assessment plan, one parent wants it, the other one doesn't. We can proceed on one parent's written consent to an assessment plan, even if the other parent objects, because all we need is one. If they both have shared custody, legal custody, it doesn't really matter as much where they live, but in terms of legally speaking, if they have equal custody in terms of making decisions about the child, it could be a weird situation where one parent has signed consent to an assessment plan or an IEP, the other parent disagrees, so the other parent files due process, and then the parent who agreed testifies on behalf of the school district. So it does create interesting situations. It would be in the situation where you think a parent might not actually have legal custody, you would want to get a copy of that court order that talks about, whether a particular parent's educational rights have been limited in any way. And I would say, though, even in situations where a parent may not have educational rights, they don't have legal custody, they do still have access to their child's records. So while they don't have decision-making authority to be able to sign off on IEPs and that sort of thing, they may still have rights to be able to access their child's educational records. And then I would say if they request 2 meetings, there's no obligation for us to do 2 meetings. You have 1 meeting, you have to try to coordinate to make it work for both of them. But all we really need is 1 parent there in order to proceed. Get them on the phone. We've done that. Yep, we've done IEP meetings with incarcerated families. So, hopefully not the whole family, but a parent. So yeah, I would try to get that person on the phone so you're still abiding by any sort of restraining order, that sort of thing. But they still have rights to their child's education unless there is a court order saying that they don't. And if parents agree to a time and place of the meeting, but they don't attend, can the meeting continue? So there was a case out of Hawaii that came out that's a 9th Circuit case, so that applies to us here in California, that was kind of this situation where we were coming up on our annual IEP deadline, but the parent was being really difficult in trying to get an IEP meeting scheduled. So when you're kind of met with these timelines where it's like, oh my God, we're gonna be late on our annual IEP, but the parent is being difficult, they wanna participate, but we just can't find a good date, I would not recommend holding a meeting without a parent. So you get everybody there and the parent's a no-show, I would not proceed with the IEP meeting without them. You can talk amongst yourselves if you'd like to just kind of chat about the student, that sort of thing, but I wouldn't proceed with anything substantive in developing the IEP until we reschedule and get the parent there for an IEP meeting. So it's all about documenting our attempts to get parental consent. Even if the parent had agreed to it and then there are no-show, I know that's difficult, but we would want to reschedule it when the parent can be there. Let's see. Referral from a parent goes straight to assessment? Maybe. I don't know, Carol, if you want to weigh on this just procedurally, how, like where the referral goes and then how that happens. But I mean, typically if a parent is saying, I want my child assessed for special education, the special education side of the house reviews that and determines whether or not they think an assessment is warranted. If so, they send an assessment plan with prior written notice, with the parent's procedural safeguards. But it could be that you say, no, we don't think an assessment is warranted. I understand, parent, that you just went out and got yourself an ADHD diagnosis for the kid, but we're not seeing it impacting the classroom in any way, so we don't believe that an assessment is warranted. And so again, you provide prior written notice to the parent of our decision to not do an assessment and the reasons that we're not going to do the assessment. So that's not necessarily something that's just an automatic that a parent's entitled to an assessment. That's really up to the school to decide. And if they disagree with our decision, again, they can file a complaint, file a request for due process, file for mediation, that sort of thing. Anything you want to add on that, Carol? Okay. What else? Okay. As an administrator, if I observe that a teacher is blatantly not providing accommodations as outlined in an IEP, what should I do? That's a tough one. I think that you have to understand that if number one, for the most part, the school district is going to be held responsible if an IEP is not being implemented, whether it's just accommodations or any of the services. The school district could be held responsible. I would really encourage us to notify at least the site administrator that this is happening, and we want to hold everybody accountable for making sure that the IEP is being implemented. I will also tell you that there have been a handful of cases that have actually made teachers and special education staff personally liable for not implementing IEP services and accommodations. So it is the rare occasion, but when it really is just kind of a blatant disregard, I know what I'm supposed to be doing, but I'm refusing to do it for this child, and the school district has done everything that they can to try and encourage that person to implement the child's IEP, someone could actually be held personally liable. So not the school district, but your own pocketbook could be affected if you're not implementing accommodations as you need to, if it is very clear that you are supposed to be doing that. So yeah, which, as Carol mentioned, which is so important, why we want to make sure that teachers are at the IEP meetings, because it could be, maybe you don't agree that an accommodation is appropriate or necessary for a kid, and that's why you're not providing it. But we don't want teachers to take it upon themselves to just say, you know, I see in this IEP that it says extended time on tests. I know this kid doesn't need extended time on tests, so I'm not going to do it. That's where we get ourselves into trouble. If you don't think it's appropriate, call an IEP. As a teacher, you have every right to say, we need to hold an IEP meeting. This IEP says extended time on tests, and I really don't think the child needs it. I don't think it's appropriate. And we call an IEP meeting and we have that conversation as an IEP team, but we can't be making unilateral decisions and determinations outside of an IEP team. Okay, gotcha. Oops. Assessment plan, placement. Okay, so these are kind of related questions about what happens if a parent refuses an assessment plan for a student. So you've made the referral and the parent says, nope, I don't want my child assessed for special education. Secondarily, what if you have done the assessment, you've developed an IEP, and then the parent refuses to agree to the placement? So for assessment, really it's our obligation to offer the assessment plan. If the parent does not agree to the assessment plan, we're not required to, but the school district could file for due process to try to force an assessment over the parent's objection. So we would go into a hearing officer, and a hearing officer would essentially order the ability to have an assessment done on the student over the parent's objection, and that the student make the child available for the assessment. That doesn't happen very often, but that is one option. We also have to remember, though, even if the student or if a parent does not agree to an assessment, that doesn't end our child find obligations. So maybe they don't agree right now, but let's try again in 6 months. Say, you know, or maybe a year from now, we're going to send another assessment plan home. Now are you willing to agree to an assessment? Because we still have this obligation to keep trying to assess a child who we think might need special education services. And similarly, for a student who's been assessed and we've developed an IEP and the parent is refusing, if it's an initial IEP, again, we have the choice, if we wanted to file for due process against a parent, to basically say to a judge, look, we think this kid needs special education, and the parent won't agree to it. However, again, that's a discretionary thing on behalf of the district. If we're talking about a situation where a kid's already on an IEP, and so let's say, for example, the student's been on a regular education campus receiving some RSP support, but we've developed a new IEP where the child really requires a special day class placement, much more structured, smaller classroom environment, much more support. We really think this is necessary for this child in order to receive FAPE, and the parent won't agree to it. We actually have an obligation. The law says you shall file for due process against a parent when you have offered something in the IEP and they won't agree to it, if you think that it's necessary for FAPE. There was a case not that long ago that came out of LA that basically said a school waited 1.5 years before they filed against the parent because they were trying to work through that IEP process and trying to get the parent to agree to an IEP. And they waited 1.5 years to file against the parent to try to force the placement that they thought was necessary. And the judge said that was too long. You needed to jump on that much sooner and file a complaint against the parent. And just because you file a due process complaint does not necessarily mean that you're going to be in a hearing. 98% of the cases that are filed at OAH end up settling through mediation or some sort of alternative dispute resolution. So it just gets that ball rolling of us meeting our obligation to file for due process if we need to. Okay, last question. Okay. Okay, last question. If a student has more than one general education teacher, are all teachers required to attend? That's a great question. They're not, only one is required to attend. I would say if you can have multiple teachers, because sometimes students look different in PE than they do in math. So sometimes it's valuable information for the team to get that input from multiple teachers. If at the end of the day you really can only have one general education teacher there, that's all that is required. And then what happens if they don't attend and don't provide a report? Again, that is a procedural violation of IDEA. Same with administrators. So if an administrator is not there at the IEP team meeting, that is a procedural violation of the IDEA, and we could be found out of compliance and potentially to have violated the parent's right to participate in the IEP meeting if we don't have the people there that are required to be there. With the rest of the questions, we will make sure that we put together some answers for you and get that out to you. So thank you all very much. Enjoy the rest of your day. Very well.